Well, thank you all for coming this morning. We're going to have a great event. I tell you, I have had experience with open meetings violations and with freedom of information violations. And I tell you, I tell my staff, if at all possible, don't go the FOIA route, because these municipalities, these governmental units all try everything they can do to stop you. And probably many of you have had experience with that. They'll say, oh, it's going to cost, $50 a page, or, oh, we got so short-staffed, we can't provide this information. And they'll get into that, but when you get turned down by that local unit, do you know who you appeal to? The local unit again. It's such a poorly crafted law. There's so many states that have great sunshine laws in their statute. Michigan does not have one of those. I do want to get into a couple of things. One, we're live streaming on YouTube, if you were not aware of that. Also, I want to thank Ken Melbourne, president of Merge Live, for their technical expertise this morning. Also want to thank our 3 business partners who helped defray the cost: Helix Sales Development, Associated Builders and Contractors of Southeast Michigan, and Blue Sea Advisors. Thank you very much. Our goal this morning is to educate and empower you in 3 specific areas that will impact your success in understanding and communicating with school boards and other municipalities: Bylaws, Freedom of Information Act, and Open Meetings Act. Today is a follow-up from a meeting that we had back in December. We did training on school boards, how they work, the state structure, and the comments we heard, we tried to debrief and find out what do we need to improve. The comments we heard was these 3 issues. People really want to be able to get information from their school boards and feel that they're getting stymied everywhere they go. Let me make sure I'm in the right spot here. I do want to mention, we could talk about changing school boards. We could talk about elections in general. What we can't say is vote for this or that specific candidate in this meeting. So just to give you a flavor, and you probably are aware of this, since December we've seen a trend, an increasing concern over public comments regarding the rights of parents. For example, the Michigan Democrat Party Facebook post said, "I'm not sure where this parent should be in control of what is taught in their schools because our kids is originating, but parents do have the option to choose to send their kids to a hand-selected private school at their own expense if that's what they choose to do." As if everyone who wants better education can send them to Cranbrook or some expensive private school. They can't do that. The purpose of public education in the public schools is not to teach the kids only what the parents want them to be taught. It is to teach them what the society needs them to know. The client of the public schools is not the parent. It is the entire community, the public. That's what the Democrats posted. That's what they believe. Just like the problems they ran into in Virginia, they have the same situation here. Yes?
Since you brought that up, the public school system is community school system. It's not just the parents, because all of us pay taxes towards that system. And the general idea is to teach facts, what has happened, how to do things. So it's not that every parent can choose exactly what they want each student to be taught. It's a community system. It's not just...
It doesn't, no one's saying every single parent is going to teach something. It said the parents, plural. Plural. Do you know what plural and singular is? You understand that term? Plural and singular. Plural means plural is the parents, okay? You're okay, I see where you're going. So the next we have State Representative Lee Snodgrass, a Democrat. If parents want to have a say in their children's education, they should homeschool or pay for private school tuition out of their family's budget. So this is the arrogance that we're hearing from public officials who are basically telling the parents you shouldn't have the right to be involved with your education of your children. And the way you do that, the way the plural, the parents do that, is through electing school board candidates. So we're going to talk about how you get information today. And we've got some great, fabulous people to present today. We're going to start with Keith Ledbetter to talk about bylaws. Keith's a personal friend of mine. He and I have had a lot of years of working on many issues. Keith is the president and CEO of Associated Builders and Contractors of Southeast Michigan. He runs a trade school with over 500 apprentices learning construction trades like electrical, welding, carpentry, and he's no stranger to education policy. For 15 years, Keith served as staff for the Michigan House of Representatives. He served as elected school board member and has helped launch 2 charter schools, one most recently in the city of Detroit. We also have 2 of the best attorneys for freedom of information and open meetings in the entire state of Michigan. My understanding is these 2 file the majority of all cases in the entire state. So you're going to get to hear the best of the best, and you can have an opportunity to ask questions to them. Robin Luce Herman is general counsel for the Michigan Press Association and a shareholder based in Budsell Long's Troy office. Former practice department chair of Budsell Long litigation practice and head of Budsell Long's media group. As media group lead, she and her team concentrate on areas of media law, particularly defamation issues, commercial litigation, and civil rights. At the same time, Herman serves as general counsel to the Michigan Press Association, the official trade association for newspapers in Michigan, and has over 300 members throughout the state. She previously taught law of the press in the journalism department at Oakland University. Herman has been a guest speaker on law of the press at Wayne State University, Central Michigan University, Oakland University. She has presented at many events designed to inform the public on their rights to know Michigan's Freedom of Information and Open Meetings Act. Secondly, we have Phil Ellison. Phil has been an expert in civil litigation. He's located in the Great Lakes Bay Area with special emphasis on property and water law, riparian rights, along with substantial practice in government corruption litigation, and has won some incredible cases that have been in the media. If you haven't researched Phil, you may want to take a look. He's been the David and Goliath on many, many cases. Successful cases have included the infamous Village of Oakley police scandal, resulting in an order shutting down an entire police department and discovering and shutting down 150 police service unit. Cases have been featured in state, local, and national news, including Time, The Guardian, MSN, Fox News, many regional and local newspapers. He's also been one of a small number of attorneys selected as super lawyers in 2021 and selected into Rising Stars in 2016 and 2020. Recent appellate successes included Porter versus Hill, Michigan Supreme Court, Weiner versus Chisholm, Michigan Supreme Court, Bitterman versus Oakley, published decision, Michigan Court of Appeals, 3 full reversals on the Michigan Liquor Control Commission. So we've got a great lineup, and I want to begin with Keith Ledbetter to talk about bylaws. And when Keith is finished, and with each one of them as they finish, we're going to allow 2 questions. At the end, we'll open it up for as many questions as we can get through. So with that, I would like to introduce my friend, Keith Ledbetter.
Thank you, Jim. All right, thank you for your time. Can you guys hear me all right back there? Yeah. All right, cool. Again, my name is Keith Ledbetter, President and CEO of Associated Builders and Contractors. One of the things we do is we have a trade school. We have over 500 apprentices learning construction trades. You start hearing more and more about that. There are actually things like that do exist. One of the things that the senator talked about was my previous educational background. I was elected to the school board in Holt back in the early 2000s. It was during a very contentious time in the school district. Obviously, there's a lot of passions right now, particularly as it relates to public education. Back then, frankly, I did not have any support. I didn't have anything like this to help teach me. I had to kind of self-learn it all along. Next slide, please. So my topic is a very sexy one, right? It's about bylaws. And so I know that's why we all came here today, to really be amazed by this. But there's a reason why these topics were chosen, and that is because this actually kind of helps outline what the legal obligations of the school district are. Every school board actually creates bylaws, and basically they're operational procedures. They outline accepted procedures, both the legally required and then also best practices. Bylaws are policies that boards adopt to govern themselves that address certain legal requirements and best practices. As example, board term lengths. How long of a term do you have? The number of board officers. Do you have an elected secretary, treasurer? Do you have a vice chair? And then also how that method is selected. Procedures for the annual organizational meeting, where the board will meet, special meetings, and also closed meetings, all those rules. So I suspect that we have really kind of two groups of people who are tuning in today. One is sort of a group of just concerned citizens who frankly may not ever run for a school board position. So they're just concerned and they want to know what the rules are of the game. And so what I would encourage you to do in this case, if you have a particular school district that you're following, you can actually Google the bylaws of that particular school district. It'll pop up and you'll understand what the rules of the game actually are, particularly as it relates to closed meetings. That's another area that gets abused all the time. Next slide, please. So those are some of the legal practices, but in terms of some of the best practices, board member ethics and conflict of interest. I actually serve on a charter school board. Part of our process is that once a year I sign a document that says I don't have a conflict of interest. There's 25 questions about my background, and do I have any type of business interest? Is there any reason that I may be conflicted? Every board will have different policies related to that, but that should be identified in the bylaws. How committees are formed, typically that is at the discretion of the chairman of the board, but that'll again be outlined in the bylaws. How the public can participate in meetings, and that's really a crucial one, particularly during this time when we have a lot of people in the community who want to interact. Some boards are different in that they're very open about it. There could be multiple times during the course of the discussion in the agenda where you're able to have public comment. The challenge that I've seen in the past, and one thing I did not like, is they would have the entire board meeting, and then at the very end, they would allow a parent to make a comment. By then all the business was done. Or they have the comments up first when you don't really know what's being discussed, right? And then the challenge is, well, I spoke, and now you said, I want to be able to comment to what you just said. So those rules about how they identify members of the public are identified in the bylaws, and or it could just be a policy, but to understand what that policy is. I'm an open government kind of guy. If there is someone who wants to have a word in a public meeting, I generally err on the side of that. Of course, you can get distracted, right? Because there's sort of a flow of the meeting. And so, if you're taking questions from the audience at every step and turn, you're never going to get anything accomplished. So it's really important that respect go both ways, that the boards are open to the comments of the community, and that the community also doesn't try to take over the meeting and do stuff that isn't really helpful to the meeting itself. And then also best practice, what powers or authority does the board choose to delegate to the superintendent? Those are typically addressed also in some type of administrative procedures document that exists. So we'll be talking about this later with people who are much smarter than I am, but it's common and prudent to incorporate policies that ensure compliance with the Open Meetings Act. So again, how you actually set those meeting notices, how much in advance and so forth, those are typically covered in the bylaws, but it's from the statutory framework from the Open Meetings Act. The board can choose to amend bylaws at any time. So that's very important to know. Of course, the bylaws will often outline what are the rules to change the bylaws. There may be some public notice, there may be a 30-day requirement or something along those lines. But once they have been amended, the board must be in compliance with the bylaws that they have adopted. And then again, I mentioned before, if you don't know where to find the bylaws, typically if you look at your school district and you type in that school district name and bylaws, those things will pop up very quickly. So the bylaws in practice are procedural policy, but they often don't get a lot of attention. You don't know that you need them until you need them, when you want to know what the rules are, because you feel like maybe the existing administration is a little bit overbearing and not being fair to the public. Most school districts use a policy called Neola to ensure that their policies are current. So they provide updates twice a year. And what you'll actually notice, if you go from one set of bylaws to another between school districts, you'll find out that they're very, very same. They may actually be identical. So that's because there is this subscription service that you can get. And it doesn't mean just because you adopt the standards there from Neola that you are limiting in any way the board's ability to make some changes on their own if they so choose. So next slide. Next slide. Next slide. I'm sorry, I didn't give you the clue, did I? Okay, so Walled Lake School Bylaws. So as an example, I pulled up the Walled Lake School Bylaws and looked at them, and you'll see these same topics in pretty much every one of the board. I actually looked up Livonia too, and the Livonia schools were quite a bit different, but a lot of the school bylaws that I pulled up follow this exact same format. First of all, the organization and functioning of the board, things like board composition, how many members they have, the term of office, the oath of office, what do you do in cases of vacancy, duties and responsibility of board members, the role of individual board members, code of ethics, confidentiality, conflict of interest, the committees that are created, election of the officers of the board, vacancies in other position, what can you be removed from office, or censorship, compensation of the board members, reimbursement of expenses, indemnification. In other words, if we are to be sued, are you indemnified? Discipline and removal from a board position, and then also meetings of the Board of Education, things like the Open Meetings Act, regular meetings, special meetings, and then also, as I mentioned before, the adoption or amendment of bylaws and policies. They will actually lay out the process by which the board can actually change the bylaws. And you should recognize that it's really the board's responsibility and it's their bylaws, so they are able to make those changes. Next slide, please. So there was a couple of them that really jumped out at me when I was reviewing some of these. One is role of individual board members. An individual board member lacks independent authority. And this is important for those of you who actually may want to be on the school board or run for school board. Individually, no school board member has any statutory power. They can't have their own negotiations with staff or those type of things. They only are given power through the majority of board vote. That's very, very important, and sometimes board members lose sight of that. One of the interesting notes that I saw in one of the set of bylaws, it says, I will abide by majority decisions of the board while retaining the right to seek changes in such as decisions through ethical and constructive channels. So that's, in a sense, that's almost like a value statement that's included in that bylaws. I'm not saying it's good or bad. I think there's, in many ways, that could be appropriate, that you're not undermining the board's ultimate authority, even though you may disagree with that. And then another one that really struck me as quite interesting was, I will strive for a positive working relationship with the superintendent, respecting his authority to advise the board, etc. So why that is important is that in many cases, and I'll talk about this in a minute, I was elected as an outsider. I was a disruptor. I was the guy going toe-to-toe with the superintendent in the media and in the public, and here all of a sudden now, according to these set of bylaws, I'm supposed to play nice with him, right? It's going to be an interesting balance between those two, and I'm going to actually talk about that in a couple minutes. And then also in the bylaws, by a 2/3 vote, the board may censure an individual board member. So there could be punishment if somehow they aren't doing the right things and they're breaking the law or not following the bylaws. The board may petition the governor to remove an individual board member from the board for any reason permitted by law. Next slide. A couple other things that are important today. Obviously, a lot of public meetings have gone to electronic and remote format, so they will lay out in the bylaws what those requirements are, how that is to be done. Public recognition of speakers and so forth, or whether you're supposed to be on camera, those type of things. And then guidelines for public participation at board meetings. Again, probably everyone in the room has some degree of interest in this. There is the ability to limit the time of individual speakers. I mean, no one wants to be there for 4 hours in a public meeting hearing someone go on and on. So it's appropriate and allowable that there is a limit of the time. Requiring individuals who wish to address the board to identify themselves in their address. That is, again, a very appropriate thing. Some people may say, well, I have my right to come in here and say what I want and not be identified. And I don't know the legal behind that, but I'll just say generally that is adopted in the bylaws. It's appropriate and they're not necessarily trying to spy on you. It's just, I went and spoke to my local township board a few weeks ago and, I identified myself and gave my address. Advising the public that generally the board and individual board members will not directly respond to comments or questions that arise during public participation. Here's where I've seen some board members not do the appropriate thing. They don't like something that a public speaker says, and then they start having a debate back and forth, and then the speaker says, stop the clock, this is on my time, and then there's this back and forth. It's much more appropriate, and as a sophisticated board member, you let them say their piece, and although you as an audience member petitioning them for something, you want to know their reaction. If they're smart, they're probably not going to get into it with you, and if they lack that discipline, then it's going to go downhill very, very quickly. So my suggestion is, and frankly, again, a best practice is, if you're a board member, don't engage with that person and argue because you're not going to win that one. Requiring individuals who wish to address the board to direct their comments to the entire board, not to individual members. You can't get up there and, you rascal over there, you SOB. Not a good idea. In the Michigan House of Representatives, anytime you get up as a person and you're making, as a representative and you're making comment, you say, Mr. Chair and members. That's how you address your comments. So when a board member, or frankly a member of the community, they're really not supposed to address an individual board member, but the board members as a whole. Prohibiting behavior that is abusive and discourteous. So I think we all get very passionate about what we believe in, right? And they feel passionate about it, and we feel passionate about it. But if you really want to be effective, it's probably good to dial it back just a little bit. I know it's maybe not a popular thing to say in this environment, but it's true. So if we can just kind of withhold a little bit of that really incendiary rhetoric, you're probably likely to get a little bit further. Again, that's my own opinion. That's not law. But excluding from the meeting an individual who engages in conduct that constitutes breach of peace, right? Being dragged out. Again, that could be in the bylaws as well. Next slide. So, okay, this is it. So, as I mentioned, I was an outsider. I was the guy. I was the bomb thrower, probably like a lot of you in the room, right? And so they did not love me. So this is some of the stuff that was going on. We had a ton of controversies. We built a $73 million high school, and we couldn't fit all the kids in it. And we were kind of from an area that really wasn't all that wealthy, and so there was a lot of controversy. Next slide. So what happens if you get elected as an outsider or disruptor? Is your goal ultimately to generate headlines, or is it to bring about change? And that's a really key question for you to ask yourself, particularly if you desire to actually take that next step and going to public service. Because my goal at the end of the day was to make some changes, and I thought that they were going down the wrong path. When I started out, man, I was blistering them, right, on the MBEEP scores, like Ledbetter's pounding away. that these scores are not appropriate, and when they thought about maybe raising a tax, I was just like blasting away at that. And frankly, it got their attention, right? I mean, I had to do a little bit of that caustic stuff to get their attention, and then really be able to articulate a different side. And I don't regret what I did, but next slide. So sometimes combativeness can be a powerful tactic to achieve influence, but it's never the goal. You don't want to be the jerk, right? You want to be the person that actually is well respected. And then at some point in time, you actually need to dial that back a little bit, because the bomb thrower is rarely that person in the room that's going to be part of the policy decisions. They're going to have that conversation without you. So at the end of the day, your goal isn't to be that bomb thrower. Your goal is to be someone who can be effective. Next slide. So, okay, you get elected. My advice as that guy who was probably like a lot of you, be a positive influence. Running a political campaign is different than serving in elective office. Upon election, you must pivot. I remember I used to do a lot of political stuff back in the day, and then these people would come as legislators to Lansing, and they're gonna run their campaign in Lansing in a policy-making setting, and it's like, hey, we got to dial it back now. I mean, you're here. And now we actually have to influence public policy. That's same on the school board level. You have to pivot from being that person who is doing the active campaigning to someone who's actually going to be helpful in a process of making policy. You actually, in order to be effective, you're going to have to find a way to build trust. And again, even though we disagreed, and we had to find a way. So I'll tell you that, so being the bomb thrower that I was that first year, I think they realized, boy, this guy could do a lot of damage quickly. And so the chairman of the board said, hey, Keith, why don't we go out and why don't we do regular breakfasts in the morning to get to know each other a little bit. And I was open to that, and he was open to that. He was probably open to that because I was really effective at doing what I was doing. And he was going to try to see what he could do to temper that. But it created a relationship. And he said, Keith, here's the deal. And the superintendent said the same thing to me. He said, Keith, we understand that we have a difference of opinion, but rather than making a spectacle in the meeting and making us look bad and whatever, talk to us in advance. If you can look over that agenda in advance and call us up and say, hey, I have some concerns about this, this, and this. Can we get these things addressed? And so now all of a sudden, I'm actually having some influence. When I got there, I actually had one member who was like me. So out of a 7-member board, there were 2 of us. Then he announced shortly after that my buddy was leaving, and then it was just me. And they're like, oh boy, this is going to get miserable quick. But there's some things that I was doing behind the scenes to try to be more influential. They weren't changing my mind. They weren't changing my perspective, but they were actually in some way beginning to extend an olive branch. I was actually smart enough to pick up on that fact. Board members are not administrators, they're overseers. I run 2 nonprofit boards as a CEO, and it is a pain in the neck when I've got board members that are going to try to get into the daily operations and tell me about my staff, what I need to do with my staff. So you have to understand, what is a board member role? Their role is not to run the daily operations of the school district. That's really up to the superintendent. Be open to communicate outside of meetings with colleagues, administrators, and parent activists. I'm not talking about necessarily deciding on how you're going to vote on an issue. Again, that's covered in the Open Meetings Act. But just be social and friendly with these people. Again, even though you may have some disagreements. Participate in planning conferences, graduation ceremonies. That was us at the Breslin Center for a graduation ceremony, and probably they didn't love me back then, but it was also important. You feel like there's them and then there's me, and I'm just one, and they've got 6 of them or whatever. By participating in those things, you're not isolating yourself. Again, you become a much more effective at the job. Next slide. And actually, I got this really great piece of advice a few weeks ago, and I wanted to mention that. Allow your opposition to maintain their dignity, right? I mean, there's sometimes when you're going back and forth on an issue, and someone actually may make a really good point that when you think about it, you think, maybe I need to have a little bit different of a perspective on this thing. But, if they don't give you any out, if they say, well, you're a real knucklehead that you thought this certain thing, then pride is going to get in the way and you're not willing to actually, agree, that they may actually be making a good point. So always give an opponent an escape route. So, obviously the mask issue is a big one that's going on right now, and things are changing very quickly. But an example, wrong way would be, you've been bullying our kids for too long, time to admit you were wrong and lift the mask mandate. Probably not going to get anyone to change their mind. Just a helpful hint there. But something along the lines of COVID isn't the threat that it once was, I think we need to revisit the mask policy. So a reasonably minded person may think, well, you know what, things are changing a little bit. We may agree or disagree whether it was good in the past, but let's move beyond that. The reality is now that things are changing and there will be a point in time. So maybe it's a good time to have that conversation. So you're giving them an out. So as you're interacting with public officials, whatever role that is, whether you are the audience member and trying to get a change, or whether you're that board member working within the confines of the system, give your opponents an out. Don't make them have to admit that they're a knucklehead or that they were wrong all along or that they were a bully or those type things. Name calling, that doesn't really work. I want you guys to be effective. And so you have to understand the best way to be effective. And with that, there ends my presentation. And I guess we're allowing 2 questions for now. Yes, ma'am.
I have a question. When you were showing some examples of the language around the role of individual board members, I've seen some of the language for our district, and I'm curious if it's possible for if that language is allowed to prevent us or prevent the board from attending community town halls or where it says you aren't, of course, an individual authority, or you don't have any individual, that's not your purpose, but can that language be used to restrict you showing up for an open invitation to board members to engage with the community and actually talk about it?
I can't imagine that they would be restrict your abilities, particularly as an elected official, to attend any group or meeting, whether you agree or disagree. I think maybe where a challenge might come up was they may say, well, might make us look bad, right? You can imagine maybe some meeting that if an official board member were to attend might send a public message. So not that it would be illegal or that you would want to have an official policy, but that would, again, probably be one of those private conversations you have. Is like, hey, Joe, probably not a good idea for you to be at that meeting, just a word of advice. But in terms of demanding that they not show up, this is America.
Yeah, or putting you in timeout and, then asking you to be removed.
So I only have 2 questions, and you were the next one to raise your hand. And
when the board has different committees that they need board members to serve on, and there's maybe 1 or 2 that always want to do it and they think differently than the other board members, when they go and represent the whole board, are they representing the whole board's opinion collectively or their opinion?
So that's a great question. And a board member is really supposed to be representing the entirety of the organization for which they represent, and even in a public board position, it's really the entirety of the community, to the point of the gentleman who spoke earlier. Really, it is to represent the entirety, not your own personal interests. And again, I serve on 2 nonprofit boards. What we tell our new board members is you have to set aside your own parochial interests. Now you're representing a much larger group of people who don't have your same business interests or so forth. So that absolutely is very important, that you have a different framework. When you're an elected senator or state representative, you're not representing yourself. You're representing your area. And so one could make the argument theoretically, and this is actually up for debate, but that you could actually vote against your own your own opinion because you think that you're there to represent the community. So it's an interesting dichotomy for an elected official, right? As they approach an issue like this, it's like, I'm not aligned with my community on this. So what do I do? And I've been around elected politics for 25 years. So it's an interesting problem for any elected member to face, or a board position.
Is there anything in their bylaws that say, as you're going to represent us, we collectively believe this and you need to go forward that way, or could they go rogue if they really want to?
So, there should, that could be addressed in a best practice in a bylaw, probably not, but it's more of, there's standards for nonprofit service, and they address that issue in those standards. That is kind of nationally recognized standards for nonprofit service. They talk about who you represent.
Is there a way to find out when they represent you, what they're doing at those, or what kind of opinions they're sharing or relaying or anything like that? Is there a way to get that kind of information?
With an individual committee member, as an example?
Yeah.
So one of the issues that came up earlier is, again, this get into different areas, but if you're on a committee, typically they do not have a quorum. And so, do they have an obligation to share, records and things like that? And that, again, that may be addressed in a different section. So I won't go there. Typically, if you would hope that an elected official would be open and transparent. And again, I think in these day and age, that may not be true. And I don't think that we've done a really great job of educating our new elected leaders, particularly in the day and age of term limits, right? I mean, they're kind of unsophisticated. They don't know how to do this stuff either. They don't know what the rules are. So it can be an issue. What I was mentioning earlier, care, loyalty, and obedience. There is a duty of care, duty of loyalty, and duty of obedience. That is the role and standards by which any board member in a nonprofit is to act. And so some of that really kind of applies in this particular setting too. So I'm getting the hook. I got to roll, but there could be further questions at the end. Thank you for your time.
Yeah, we're going to give plenty of, give Keith a hand. And there will be plenty of time for questions because we are streaming live in case people want to get right to the presentations and then on. I want to keep it moving, but we'll have plenty of time at the end. And Robin, if you come up and begin your presentation.
Good morning, everyone. I'm going to talk to you about the Freedom of Information Act, but before I get into my presentation, 2 points that I wanted to follow up on. First, Keith's point, in Michigan, there is no required training for any elected official on the Freedom of Information Act or the Open Meetings Act. I actually have attended some of the training that is offered, and it's awful. It is truly awful. So one thing to keep in mind is that your elected officials really may not know their obligations. And I'm sure Phil will back me up on this. Many of them have never read the Freedom of Information Act or the Open Meetings Act, which are both eminently readable, right? So that segues into my second point, which is something that the senator brought up. Phil and I are advocates for our clients. We're advocates for transparency. There needs to be changes to both the Open Meetings Act and the Freedom of Information Act. And the people like you are the ones that are most likely to convince our senators and representatives in the legislature that those changes are needed. So if you care, if you think that changes need to be made, write a letter, send an email, give a call, let Lansing know, because you have the ability to influence not only the Freedom of Information Act and the Open Meetings Act and necessary changes, but also your local school boards and their policies and procedures, right? If you disagree with them, let them know. So with that, I'm gonna do a quick run through the Freedom of Information Act for you. I just wanna make sure, okay. So the mission of the Freedom of Information Act, according to our legislature, is to entitle us to full and complete information regarding the affairs of government and the official acts. That's so that we can fully participate in the democratic process. That is, vote for those issues and persons that reflect our view. Public bodies has a specific definition in the Freedom of Information Act. And interestingly, it's not the same definition as the Open Meetings Act, which Phil is going to be talking about. So for purposes of FOIA, it's created or primarily funded by a state or local unit of government. And then it lists a lot of other local units of government. But, and this is a big one for us advocates, the governor, lieutenant governor, their employees, and the legislature are currently specifically exempted from the Freedom of Information Act. A public record is a writing that is prepared, owned, used, or in the possession of, or retained by a public body in the performance of an official function. It includes emails, it includes digital pictures, if they relate to the official functions of government. So it's a very wide definition of what constitutes a public record. One of the things I want to do is make sure you have some extra tips about dealing with the Freedom of Information Act. As the senator indicated, if you can avoid FOIA, it's a good thing to do because chances are likely that if you send a FOIA request, there's going to be a delay in getting the information and it may cost you, right? So you want to check the public body's website first. Both at the state level and at the local level. Keith was talking about information that is available like on a school board website, bylaws, things like that. Here in Southeast Michigan, that's highly likely. In places outstate, not so likely, right? But you always want to check the website first and information may be available. FOIA does not apply to the courts. People think you can send a FOIA request to the courts. No, you can get them, you can get records from the courts, but it's not based on the Freedom of Information Act, and the Freedom of Information Act's fee structure does not apply to courts. The bane of our existence when you are a FOIA requester are the exemptions. There's a laundry list of exemptions. And what that means is that the public body can withhold an entire document or portions of a document based on an exemption. And I'm going to come back to that. There are two kinds of exemptions under Michigan's Freedom of Information Act. And I want to emphasize here something that the senator said. Every state's Freedom of Information Act is different. No two are alike, and the federal Freedom of Information Act is also very different. So you may be a transplant from another state. You have to check our laws here in Michigan. We have two kinds of exemptions. There's mandatory exemptions. That means that the public body has no choice but to redact that information. And there are permissive exemptions. But there's only one mandatory exemption under Michigan's Freedom of Information Act, and that is FERPA, educational records. And that doesn't mean all educational records. It means certain educational records of an individual student that are in their student file, right? So if you, for example, want to know from your local school district, what are the range of scores? How many people did we graduate? FERPA would not apply. But the rest of the exemptions are permissive. They require the public body to weigh whether or not to provide the information. And when they look at a document, they are required to separate exempt information from non-exempt information. So to use a very easy example, assume that you wanted the personnel file. Or I'll make it even easier. Let's assume you want the applications for the music teacher position in your local school district. You can get those applications, but there's probably a social security number, right, on the application because there's going to be a background check, that sort of thing. They can't withhold the whole application on the basis that there's a social security number, they have to block that out, redact it in FOIA speak, and give you the rest. The statute requires them to separate the exempt from the non-exempt. Some of the exemptions that we deal with on a regular basis are privacy, for law enforcement ongoing investigation, academic transcripts, national security, archaeological sites. There's a whole bunch of them. We can't cover them all today. So the other thing that happens is when you make a request, the public body can, under certain circumstances, charge you for the documents that you want, which is another reason, remember, to check on the website first. They cannot charge you unless, one, they have adopted a fee policy. They have to have a fee policy or they can't charge you. Two, fulfilling the request would result in unreasonably high costs. So a request that would cost, that they want to charge you $5 for would not fit that criteria. But as a practical matter, people pay it because they don't want to fight it, but they're not allowed to charge it. And they have to identify those unreasonably high costs. So there's some special rules with respect to fees. They can't charge you if they know, for redacting, if they know that they've previously redacted the information and they still have the document. They can't charge you for records available free on a website unless you insist. So in other words, you send a request and say, I want the bylaws. They respond back to you and say, here's the website. They're on the website. Here's how to find them. And you say, no, I want you to give me a copy. Then they can charge you. You do have the right to inspect documents. So you can say, I want to come in and look at this file. And I want to select which documents I want. That helps limit or eliminate costs. They also can charge you a deposit, but only if the estimate of the costs is more than $50. And then they can only charge you half. There are some special rules for indigency that you can give an affidavit. But you only get so many free records responses within a certain period of time. There's a special fee for nonprofits, for certain nonprofits, and for gathering information they need for providing their services. If they're late in responding to your request, you get a 5% discount. They can't charge you more than 10 cents per page for a standard, 8.5 by 11 or a legal size. And if they have the ability to do it double-sided, they have to do that. They can only charge you the actual costs for electronic media. But here's where the costs go up. The charges for the employee to process your request. They have to charge you the hourly wage of the lowest paid capable employee plus the cost of fringe benefits, right? They can use outside contractors, but there's limits on that as well. There have been some recent amendments to the Freedom of Information Act. There's now an address requirement. You just have to give them a U.S. Postal Service compliant address. You need to give them contact information. And once they respond and say, okay, it's going to cost you $50, you have to give us $25 as a deposit. If they don't receive that within 45 days, they deem your request abandoned. So let's talk just for a couple of minutes about keys to good requests. Written requests are best. Some, they're not required to take an oral request, and some public bodies don't. You want to be fairly sure that the document exists. One way to check on that is the Department of Technology. What's the M? Thank you. And budget. Yeah. They have a retention schedule. They have these long lists of all the documents that public bodies are required to keep. And it's very interesting. So, for example, they have a whole list of things for airports that they have to keep, certain logbooks, certain budgets, things like that. So you can go on the DTMB website, you can look for townships or school boards, and you can see what sort of records they're supposed to keep. So if you're not sure the kind of record that you're thinking about exists, that's a good place to start because you want to ask them for that. You want to be focused and detailed. And that's a really hard line. Too short can be too vague. Too broad can cause undue delay and expense. So one way to think about it is I get cold calls from people that say, I sent out this request and they want to charge me $2,000, right? And they requested emails for anyone in the public body for 6 months, right? That's going to cost a lot of money, right? But their theory is, hey, there was this thing that happened at a public meeting that I found, I didn't understand where that came from, and I think it goes back. Well, in that circumstance, start short in time frame and build out, right? You don't need to try and get everything at once. What you want to do is get the narrowest, most specific information you can as your starting point. And then you can send follow-up requests for it, right? And candidly, some public bodies try to scare people off with fees, right? And some public bodies are specifically told, you will not engage in a discussion with a FOIA requester, right? So again, you don't want to be too short. You want to be specific and as focused as possible. Another thing that people don't take advantage of very often is FOIA provides for subscriptions for regularly created documents. And you can say, I want this information for 6 months, and then you can renew it. So where does that come in handy? Well, as Phil will tell you, under the Open Meetings Act, they don't have to give you an agenda. They don't have to post the board packet. They don't have to do any of that stuff under the Open Meetings Act. But you can send a subscription under FOIA and say, hey, I want the agendas, right, for these meetings. I want the board packets, right? Other like budget information, but recurring documents are something that you can request. So to give you, an example here, you'll see I write to request all communications between Susie and Johnny here for 4 days relating to a board meeting. Or I want to request the monthly progress reports, right? Those are some examples of good, fairly narrow requests. As the senator indicated, if you don't like the response from the FOIA coordinator, you're entitled to an administrative appeal to the head of the public body. You have to say that it's an appeal, and they have to respond within 10 days. But the difficulty is that some public bodies just say, hey, that's what our FOIA coordinator said. I'm not going to think about it. I'm not going to read it. I'm not going to worry about it. We're just going to back him or her up, right? So administrative appeals very frequently do not provide the relief that you want. And what's your choice then under the current law? It's to sue. That's the only thing that you can do. You should, though, if you get a response to your request that's problematic, try to have a conversation with the person. You're trying to make it more efficient for everybody. What records do you have? In what format? what's easiest, quickest, cheapest, and can I come and review, right? Those are ways to try and manage. Unfortunately, they won't always be successful, but they are worth trying. So with that, I'll take 2 questions, and then I'm going to give you a quick anecdote to kick off Phil for the Open Meetings Act. Any questions on FOIA? Yes, sir.
Yeah, you talked about going in and looking. Who set that up? That's simply a request to the FOIA?
FOIA coordinator.
FOIA coordinator.
Yes. I mean, most public bodies will list a name and the phone number, or the name, phone number, and email address for a FOIA coordinator, at least in Southeast Michigan. That's my typical experience. So I would say, I want to come in and look at these records. How do I do that? But they have to allow you to come in and look at them. You will find sometimes that they will give you a babysitter because they want to make sure that you're not destroying anything or marking something up. But yes.
You might eat the record while you're sitting there.
That's right.
Right?
Yeah. Yeah. Go ahead.
You mentioned that in Michigan, there's no required training for elected officials on FOIA for their act.
Correct.
But it sounds like there is training offered through other entities.
Through some, I don't know how widespread the training is.
Okay. What kind of entities offer that?
So my understanding is that the Michigan Township Association provides some training to their folks. Also, the Michigan Municipal League and MSU Extension has offered some, which I've been to. The one other entity is the Michigan Association of School Boards. They offer training, a lot of training. They have a great handbook, an open meetings handbook. Phil and I don't agree with everything in it, but there's lots of good stuff there. But not everyone's required to do that. I mean, my experiences with school boards, it's like, hey, do you want to go to this? And if they go to anything, it's sort of, they start with school board orientation to understand your duties, and people don't go to the FOIA or OMA sessions.
But I guess the sessions are really going to vary based on who is putting them on, because it's that organization's understanding of the laws and maybe them trying to promote their own interests.
Yeah, so I'll give you an example. So I won't give you all the background, but I was at one training that was OMA training, Open Meetings Act training. And when they got to the part about closed sessions, they provided no training. They said, we're not going to train you on that. Talk to your own attorney. And I'm like, what? What kind of training is that? I mean, if you're a member of a public body, posting the notice and all that kind of stuff, that's really administrative. Where the rubber meets the road is going into closed session. No training on that. So, all right, so that's our 2 questions. I'm going to give you my quick anecdote as a kickoff to Phil. So I'm of a certain age. We had to do U.S. government, junior year in high school, anyone, And so you had to do a Freedom of Information Act request. You had to go to an open meeting. So I went to my school board meeting. Now, I had gone to the Catholic high school through 8th grade, and there was a middle school in my hometown, small rural farming community. And they had a tradition in the middle school. The 8th graders had fundraisers, and then they gave a gift to the school, right? Gave a gift to the school. Well, they were still left over from our parents, called them sock hops. They were just basically a stereo in the gym, right? So the 8th grade class, that's what they wanted. They wanted to buy a new record player for the gym. And the school board was like, no, we actually think we should use that money for wrestling mats. And so I stood up and I said, look, that doesn't make any sense to me. It's a gift from the school, from the students, and wrestling mats seem like a regular school thing. And so the head of the school board said, well, yeah, Robin, but you don't really know what you're talking about because you went to the Catholic school, you didn't go to the middle school. So, basically, you have no basis from which to speak. So I stood up and I said, yeah, that's true. I said, but I was under the impression that the school board was here to work for the students, not that the students were here to work for the school board. And then the next day, the principal came up to me and said, if you ever go to a school board meeting again, we'll suspend you from school. And I said, you do that and I'll sue your...
That was a great story, and it's what we're dealing with here in this nation. If parents and grandparents don't get involved with their kids' education, there's so many people that I've talked to that are my age and older and said, I'm so glad I'm not a young person because what they're going through. Well, it's up to us to stand up and make a difference. Before we go to our last presenter, Phil, when we had these events before, we would just quickly have the person say their name and what school district they are, take a quick break so you could kind of have some synergy there. It's amazing how many people say, I had no idea you were from the community. So we'll start here. If you could just say your name and your school district, and we'll go as quickly as we can up and down the road.
Morning, I'm Jacob Dimmick, Huron Valley School District.
Yeah, just go down. Yep.
Nathan Malcolmus.
Joe Courtney, Huron Valley.
Regina Bialetti, Huron Valley.
Saul, Huron Valley.
Roger Downey, Columbia School District, Jackson County.
Are you guys board members or that's just the school district you're from?
School district.
School district, okay.
Next summer, West
I was gonna say, wow.
Dan Mahon, Walled Lake School.
Michelle Missile, Huron Valley. Marlene Pollitt's, Walled Lake.
Chris Taylor, Novi.
Southern Nicola Rochester Middle Schools.
Sawmill and I'm sorry. That's okay. Walled Lake. Leah Straka, Dundee.
Sawmill and Walled Lake.
Linda Bullard, Howell, Livingston County. Kay Long, Huron Valley. Shannon Seco, Wyandotte, Union County.
Raj Bussman, Novi.
Frank Kavanaugh, Huron Valley School District. Jim Taylor, Huron Valley.
Desiree Dragon, Huron Valley, and Walden Consolidated Schools.
Renee Bonavides from Midland.
Marcy Enriquez, Oxford, Oakland County.
Michelle Greenwell, Rochester.
Julie Fernandez, Walled Lake.
Hanford Road.
Carol Brusha, Rocio.
From all over, aren't they? It's kind of
Karen
impressive.
Phillips, Linden.
Dan Jeminick, Walled Lake.
Kinsey Wilson, Walden.
Midland.
Tim Fountain, Grand Ledge, Public Schools, Union County.
Sarah Vincent.
And Walled Lake.
Good morning, I'm Nikki Snyder. I'm a mom of 3 from Dashler Community School.
From Harrison, again. Hello, Matt Nelson, Walled Lake.
Christy Petroni from Clarkston.
Morning, Tanya Struble, Huron Heights District 7.
Michael Vickmeyer, Walled Lake.
Terry Hughes, Saginaw. Alex Keller, Clarkston.
Nathan Paul, Walled Lake.
Terry Prince,
Brian Watson, Huron Valley.
Maria Giancotti, Birmingham, and Teresa was also kind enough to help me mention that I'm here with positions today. And then unlock 2 as well as security.
Lou Miles, Chippewa Valley, Macomb County. Robert Wojtovich, Chippewa Valley. Paul Giampa County, Clarkson. Eric Davidson. Ross Franco, Walt Lake.
In the back? Okay. Thank you. And let me get just an opinion whether there's any issue with signing those. I don't think there is, but just give me, and let's take a 10-minute break. I want you to be able to.
Oh, Matthew Donato, you're on Valley.
So we're going to take a 10-minute break, kind of get to know each other, and then come right back, and we'll finish up. Okay, everybody, please get back to your seats. We're going to get started. Everyone back to your seats. Please get back in your seats. We're going to get started. All right, please get back to your seats so we can get started. Thank you, and we're not going to be permitting the signing of petitions here at this event. We just don't know what that's all about in terms of the rules, so we're not going to permit it. Okay, so next we have our last presenter, the David and Goliath, Phil, to come up and talk about both freedom of information and open meetings.
Open meetings here. That's the coin I got on this one here. Thank you very much, Senator. I appreciate it. Again, my name is Philip Ellison. I am an attorney. Don't throw the tomatoes. So Rob and I have known each other for a while, and of course we'll be the first to tell you we're biased and we're prejudiced. And the reason why we're biased and prejudiced is that we're biased and prejudiced towards transparency. And one of the difficulties that we run into is that we run against government and government officials who, whether intentionally or for political expediency, don't want to be as transparent as required. So unfortunately here today, and I should say fortunately or unfortunately, one of us had to do the FOIA case and one of us had to do the Open Meetings Act case, but I can tell you we're both equally well versed in both of these areas of law. So she, I think, got the little more fun one, but hey, we'll talk about that. One of the things that I tell my wife is a school board president, okay? And of course, it's added for some interesting conversations when you have come home and find out that someone's trying to start a secret text ring to discuss issues that should be discussed at a meeting open to the public. And of course, one of the things you find out is that a lot of times these open meetings, which are supposed to be open, where these issues are being deliberated and decided, are in fact discussed, decided, and pre-voted on before the meeting even occurs. And of course, that is a violation of the basics that we have here in Michigan for our meeting process, which is the Open Meetings Act. Now, Robin was nice enough to point out that these two laws work hand in glove together, but they do have some differences. But the important part is they both are designed to make us what we call a sunshine state, a state that is supposed to be as open and as transparent as possible. Unfortunately, the way that the laws have been interpreted by the courts have been tweaked and fought and twisted by government attorneys, and particularly government insurance attorneys who have to pay the bills for when these government officials screw up. A lot of the enforcement mechanisms that exist for Open Meetings Act and FOIAs are largely been handcuffed. They're not gone, but they've largely been handcuffed. And so one of the things that I'm going to echo before I get into talking about the Open Meetings Act particularly here today is I echo strongly Robin's call to arms to you guys to say we need to make sure that these laws are as strong and as enforceable as possible. Because if they're not, the problem is it becomes a parchment promise. It's simply words on a piece of paper, and they don't mean anything anymore. So with that said, get your pens, get your quills, or get your emails fired up and start emailing legislators and telling them, fix the law on that. And as the Senator knows, I have testified in front of his committee. He's one of the ones that I have his cell phone number. I can get his ear. I just don't have enough other senators' ears yet to get those laws changed and to be inputted and improved. So maybe you guys can help me with that respect. So anyway, that said, I'm here to talk today about the topics of the Open Meetings Act. Now, the Open Meetings Act is itself designed to basically be the base solid rules for how a public body, and that's a defined term under the statute, a public body is supposed to conduct themselves in the operation of decision-making and deliberations. Now that's important. It's not just the decisions, it's also the deliberating process is also dealt with as part of the Open Meetings Act. So there's three main areas that I tend to find that public bodies screw up the most on. One is insufficient notice. One is not allowing proper public participation. And the third, and the big one is they go into closed session every time there's a political problem in the wind. And they slap a label on it that usually is not even close to what is a valid or proper process to go into closed session. So I want to talk a little bit about those today as well. But the key to all of this is that I struggle as a lawyer. I represent folks usually, as I like to lovingly call them, the gadflies who bring the lawsuits for these sorts of things. It's difficult for me to fight these kind of issues in court because a lot of times people who serve on the government bodies are saying, I don't really care about what people have to say because I've already decided what the outcome's going to be. So why do I need to waste my time and the school time, and we're talking schools here, but it's any governmental body, waste the time to listen and to hear from what the constituents have to say? And the simple answer to that question is because you have to by law. And what happens more often than not is when these government officials and agents are brought to court to account for these violations, I more often than not hear, well, this was just a technical violation, right? This was no big deal. It's just a technical. If I got a nickel for every time someone said technical violation, I would never have to work ever again. But here's the point. If you build your house 5 feet closer than the setbacks you're supposed to be, it's just a technical violation. But you bet they're going to make you change it. Especially for those, if you're here and you're on a school board or you're on a public body, you have to remember that those folks, you, or the people that are here that are electing people to that role, their job is to obey the laws and obligations that are on them because they're making laws and policies and decisions that affect how other people have to act. And what's good for the goose is good for the gander on this. I don't know if this is the right analogy, but it's close enough. So, that all said, let me jump in a little bit about the Open Meetings Act itself. So, what is supposed to happen in a normal meeting? A public body at the beginning of each year has to establish their regular meeting schedule at the top of every session. Now, that session can be, in most cases, and for most public bodies, that's the January organizational meeting each year. And they will set the dates and the times that they will have their regular meetings. And they do, usually it's passed by a motion. There'll be a motion and a second with a majority vote. Once those are established, they can change, but they can only change with notice. And one of the other things they can do is that a public body can call a special meeting. Now, a special meeting is a meeting that is not on the regular board schedule. But there's some, again, notice requirements that have to occur. One is that you have to give at least 18 hours posted notice, and that 18 hours has to be publicly accessible notice. So if you post it in the back wall of the library, let's just use this library for example, and your front door is locked, and no one can see that notice, and it's only visible for the 6 hours before, even though it's been on the wall for more than 18 hours, that's not sufficient notice. Now in today's world, we don't usually use the community bulletin boards of like we used to do in the past. So what becomes even more important, and where I see even more violations, is that you have to post it on your website in the same area that you post your meeting minutes and your other notices for public meetings. I'm seeing a lot of circumstances where folks are just not doing that. Now, it's gotten easier because it used to be before with a web design or with a website, you'd have to go to the web designer and get the web designer or the webmaster to go in there. I mean, we used to have a thing called the webmaster of each website who would have to physically change that. Most governments now have software that they can amend and edit their own website and can post these posts very simply and very easily. And it's important. These notices are important because that provides the ability for the public to know that they're having a meeting about a particular topic. Now, the notices also have to be and the notice for the regular meeting comes from the original organizational meeting itself. So what's important for that, and as Robin pointed out in what she was referencing, is that you can use these laws together to make sure that you know what's going on with your particular public body, or in your case, school boards. you can file a request for a subscription that says for every time you have a special meeting, I would like to have notice of that from henceforward. And so every time that a meeting notice is generated, whether special or general, or special or regular, the public body now has to submit to you, send you a notice of that pursuant to the FOIA subscription. So really, in a way, if you combine those two laws together with those two requirements, you really don't have to go down to the local bulletin board or check the website every day. You can actually get notice sent to you by mail or by email by utilizing those particular laws. Now, once you have notice, a public body has certain obligations about what they do once they convene their meeting. So first of all, when you have a public meeting itself, it has to be done at a place that's open to the public. Now, there's some difficulties that can come about of this. One, right off the bat, is there is no obligation, and in fact, the Open Meetings Act specifically prohibits that you do not have to give your identity or your address or sign in to attend a public meeting. Now, I can tell you this one is regularly violated because you go into most any meeting that exists, they always ask, please sign in before you come into this meeting. Now, to me, as somebody that when you're talking about open and transparent government, what difference does it make whether someone signed in or not? It's because it's politics. They want to see who was at the meeting, right? Who was in the room at that particular time. If there is a requirement that you have to identify yourself to get into the meeting, that is a violation of the Open Meetings Act. Now, where there's a stickier question is when you start getting into those meetings, what are some of the obligations that exist? So one of the things right off the point, and Kirk brought it up, is about the idea that you have to, if you want to give public address, you have to identify who you are and your address. Boards a lot of times have those policies. Under the Open Meetings Act, the board has the authority to pass reasonable rules and regulations. What does that mean? So the courts, we do this case, lawyers like the two of us go in, and we argue that that rule is unreasonable or that rule is reasonable, and a court decides on a case-by-case basis. So far, the precedent in Michigan is that requiring a name and address as a condition to speak is an acceptable, reasonable rule for purposes of the Open Meetings Act. Personally, I disagree with it. I don't think it's a requirement. I think it just adds to the political angst, and it adds for people. For example, and this is kind of an outlandish example, but it's a practical example. What if you're somebody who is a person who is a undercover police officer, or you're the victim of a abusive spouse, and you're hiding from that, but you want to participate in government activity. As a condition of being in that meeting, you have to identify who you are and where you live. And there's a public record of that now, right? So why add that unnecessary requirement? But the current precedent in Michigan is that public bodies can make that as a reasonable requirement going forward. Now, as time has gone on, we're seeing more and more of these different rules and standards, for example, about what constitutes a reasonable request or what constitutes an unreasonable request. I could spend a whole day talking about those, but just know that we don't have a definitive list that's there. It's being dealt with on a case-by-case basis as the courts are called upon to answer these questions. Now, once you're in these meetings, let me start off by saying that all votes of a public body have to be done at a meeting open to the public, observable by the public, with votes being had. Now, votes don't have to be by roll call vote. We'll talk about this one in just a second here. I thought it was my microphone there. I thought, I just tripped over something. So all decisions, every single decision with a vote has to be done in an open session at a meeting open to the public. But not all deliberations have to be done at a meeting open to the public. And what we're talking about there is that a public body, if they follow the procedures that are provided, can go into what's called closed session. Now, some public bodies erroneously call it executive session. That's actually not the right terminology in Michigan. Executive session is normally something dealt with by the school, the public universities have an executive session or a formal session or informal session. They have their own set of rules that apply to them. But here, it's a closed session. Now, there's about, depending on how you count them, there's about 24 reasons why a public body can go into closed session. Now, how you're supposed to go into closed session is a public body, a member of the public body is supposed to make a motion to go into closed session. Now, there's no request. We generally do the process in Michigan that we use for a second. We're using kind of Robert's Rules of Order. But there's no obligation to actually have a second. But there has to be a vote to go into closed session. Certain types of closed sessions have to be done by a 2/3 majority of those serving and elected. So meaning, if you are a 5-member board, you have to have, in certain instances, you have to have 2/3 or more, right? If you don't, so you're gonna need 4 in some circumstances with a 5-member board. Other ones, you can have a simple majority where 3 is enough. And the different types of closed session reasons then that's outlined in the law itself, which I will echo Robin's observation. Most public officials that I've dealt with, who I've sued in court, have never actually read or looked at the Open Meetings Act. And so a lot of times they don't know because they just haven't looked themselves. So once a public body gets into closed session, they are limited, or at least they're supposed to be limited, to having a discussion on the topic for which they are authorized to go into closed session. And of course, I've done lawsuits where, surprise, surprise, they go into closed session for one reason, and they have a conversation about something totally unrelated because that topic they don't want discussed in the open viewpoint of the public. That's a violation of the Open Meetings Act. Once a public body is done, they come out of closed session. The recommended process, but it's not required in Michigan, is that you take a vote to come back out of closed session to go back into open session. There's no requirement for that. But if you're going to take a vote to go back into open session, that vote has to be done in open session. So you essentially leave closed session, and when I'm talking about leaving closed session, you allow the public back in, you tell the camera guys to turn the cameras back on, and you're conducting yourself in the view and then with the observation of the public, okay? Once that, if you follow those kind of basics right there should be no guy like me being an Open Meetings Act attorney. This should be easy and simple and direct. But human nature is such that when we're doing things that I think that are unpopular or could potentially affect your political life if you're a politician, or you don't want people to know what you're thinking or how you're voting, it's just human nature to try to hide that information. But the Open Meetings Act was designed to counteract and both counteract and countermand that deep-seated nature that we have as humans to hide that which we're embarrassed about of what we're doing. And of course, the whole point of open and access is so that the public knows exactly what you're doing, why you're doing it, and to have the opportunity to participate in that. So lastly, the last part that I'm going to talk about here today before I open it to questions would be is where I see the most area of litigation is public bodies essentially messing up or retaliating for the public comment section of an open meeting. Every open meeting of a government has to have, and even including largely the legislature too, they got a little bit different rule, but even the legislature themselves has requirements that you have to give people the opportunity to make public comment. They call it public participation, it's public commenting on that. So again, in these circumstances, the law, you would think there would be very clean, neat laws about public participation. There's not. Public participation is done where the public body themselves can again adopt reasonable rules and regulations about how public comments are handled. And as many boards as there are in the state of Michigan, we see that many combinations and variations of those rules. Some make sense. If you're going to speak into the microphone. That doesn't seem unreasonable. If you're going to speak, we need you to identify who you are and your address. Okay, maybe. If you're going to speak, you need to identify what political party you affiliate with. If you come to the meeting, you have to tell us whether or not you have children in the district or not. You can see the variations can go. I mean, we could talk variations on this for a long time. The other part that's supposed to have, that would be helpful, that I think what was in the minds of the legislators who created the Open Meetings Act is that when there is a public comment section, it's supposed to be the opportunity for a member of the public to address the board and to address members of that board. Now, I disagree. There's going to be a piece here I was disagreeing with Kirk about that, and these are fights that are still being fought, even though this law has been on the books since 1976. I think you have the right to address specifically individual board members during the meeting. I know this is not a majority held view. There's disputes about this, and no case has directly dealt with this about whether or not that is. But that when you're addressing a public body, the members of the public body are the agents of that body, and you can address I think you can specifically call out specific members for doing specific things. But guess what happens? Things get hairy. So let's watch an example, and thankfully here today, we had someone email. I don't know how the email got to me, and she's smiling right now, but I'm using her as our guinea pig today, that she had a meeting of the Midland schools where she went up to speak. This is about a 4-minute video, and we're going to watch about what happens when she went up to do a public comment at a school board meeting.
Mrs. Bonadies, the floor is yours. Thank you for joining us.
Good morning. My name is Renita Bonadies. As you know, you've seen me multiple months now, and I've been coming for some time. Concern I have is the failure of this board to follow its policies and bylaws. After the November meeting, in which you guys rammed through 14 bylaws, by number, no discussion, I approached Mr. Lauterbach. I was told by Mr. Lauterbach that it was discussed beforehand. I questioned the Open Meeting Act because it was never discussed in public, instead behind closed doors. And then I was questioned about whether I'd even read the Open Meeting Act. And then Mr. Lauterbach went on to ask me if I was a lawyer, and basically said if I wasn't a lawyer, I couldn't interpret the Open Meeting Act. And then Mr. Hatfield joined in.
Ma'am?
Yes. I'm going to tell you.
This is not, you can stop talking, that's fine. This is not a forum to personally attack board members. If you have something to say, that's fine, but I will not allow you to attack everybody personally.
There is a point to this.
Okay, let's get to the point then. Thank you. Jeff?
The point being, this board has continued to ignore its bylaws. The superintendent has sent me a letter letting me know that this board is doing everything they're supposed to. And yet at the last meeting, you conveniently, after over a decade, dropped off the whole part of the meeting that requires approving of meeting minutes from study committees. That just happened to disappear from the agenda. There was no approval of meeting minutes. There was no reading of meeting minutes. There was no discussion about that being dropped off the agenda. So what has happened to the transparency of this board in this community? If your job
I think we got corrected.
as elected officials, excuse me, stop the clock if you're interrupting me.
Yeah, we have to correct it. The meeting minutes were read and they were approved.
They were lacking.
It was not on the agenda for the first time. It had been removed from the agenda.
No. Meeting minutes, any committee meeting minutes that
Were summarized.
That the minutes were read and approved. That's all.
There were action items on the agenda.
Okay, let's.
The point being, this board takes an oath to the Constitution and to do your jobs. Months before I even arrived, you had been called out on violating bylaws. You continue to not follow those bylaws. You don't work with the community. You're not open and transparent. It was justified that this board was allowed legally to cut down to 1 meeting a month instead of the 2 that had been done before Mr. Sharrow arrived. And the meetings, study committee meetings, have all been made private so that nobody can go in and hear what's discussed. Instead, we get to watch what happens in these meetings, which is just an agenda full of action items. I don't know how a business can have action items with no discussions and decisions being made behind the scenes. So this board is not being open and transparent. This community does not understand that you are not doing your jobs according to the election positions which you have taken. That concerns me as a community member and a taxpayer and a concerned parent of others that are in this community. So until this board decides they want to do the right thing, this board either needs to resign, be recalled, or be voted out at the next election because you're not doing your jobs. Thank you.
Thank you, ma'am.
So kind of in the where's Waldo idea, how many violations have we seen here today in what, 3 minutes time? I got this video last night before today and said, can we use, is it possible to use this? I was like, oh my God, there's so many things there. But the point of it is that as you can see in these circumstances, this is a Midland School Board. I think it's a subcommittee. Is it a sub?
No, this was a special meeting held at 8 a.m. and there were only 4 public people present.
Okay. So the point is right off the bat, you saw that there was interruption by, I believe it was the superintendent. Was first and the superintendent. Then there was, she was calling out what she thought was inappropriate policy. Now, whether they agree with that or not is irrelevant for purposes of public participation, right? She was interrupted, told she was wrong, cut off time, and on top of that is that, as you can see, as the hearing went on, or as the public participation went on, they are uncomfortable with that particular speech. They don't want, who wants to be called out and told that what they're doing and how they're acting is inappropriate. So what happens more often than not is we run into these circumstances where public bodies say, well, we're going to start cutting back on the availability of folks of the public to speak because it's uncomfortable to hear that kind of stuff. The whole point of the Open Meetings Act is designed to specifically provide that they have to sit there and hear those kinds of things and not limit that. I'm almost out of time. I want to make one quick other point, and I'll answer the 2 questions here. The one last part, the questions that come up more often than not is, every once in a while you'll have a chairman or a chairwoman who will say, if you continue to do X, I'm going to have you arrested from the meeting or hauled away from the meeting. So Michigan law there, and that is controlled by the Open Meetings Act. In order to be arrested or otherwise removed from a meeting, the board actually has to make a finding that you are breaching the actual piece of that meeting at that particular time. Until they make that finding at that particular time, the board does not have the ability to remove you from the public meeting. And so we've seen this, actually there was a really great example of this where a chairwoman of the Flint City Council, and Flint is a great place if you want to see Open Meetings Act violations, by the way. The Flint City Council chairwoman had a board member arrested and removed. Now, in fairness, this particular board member, I know I'm being recorded out in the world, but this board member is very boisterous, very opinionated, gets under the skin of certain other people. Doesn't matter. You don't get to kick them out unless you first have to make the determination that they were breaching the peace. And if you don't do that, that violates the Open Meetings Act. So, what's that? So it depends. There's weirdness in the law with that right now, but whether I think it requires a vote. But there is a line of thought that says the chairperson, who is the person in charge of controlling the board, can make that determination singularly. I don't think so. I mean, but that's, again, we start off, well, you look to bylaws, and that can be evidence of whether they have that authority or not. But But again, we go back to where I started. I have a bias and prejudice towards not having that kind of power by boards in that respect. So I could talk 4 days about the Open Meetings Act and 8 days about FOIA itself, but I'm going to stop right here. I know I'm going to be around. I think a couple of the other guys are hanging around after the meeting, and we're happy to talk to you guys about anything further, any questions you have. So I'll take 2 questions right now. Yeah.
What are your thoughts about school board or BOEs requiring your questions to be submitted prior to the meeting?
So again, that fits under that same rubric of, is that a reasonable rule or regulation that controls the way the public participation? I'm guessing what you're meaning is submitting a question ahead of time. So some boards have, and I guess I'm going to qualify by what you're saying, some boards have a policy that you can submit questions that they will attempt to answer, and then they have a separate public participation portion of the meeting. So they have both. I've had other boards where it's like you have to have, I've seen other examples where you submit questions ahead of time, and that is your public participation. Simply submitting the question is the public participation. There's also, and I'm going to take you one step further, there's also rules that have been developed that have said, in order for you to speak at a particular meeting, you have to pre-register with the board to have that public comment opportunity. I personally think all of those violate the Open Meetings Act. But the question would be to the courts would be, because the legislature didn't define those specifically, the courts would be the one to decide, is such a regulation or rule reasonable or not for that particular board? Yeah. Yeah.
I see it as them filtering out questions that they don't want to address.
Correct.
I've encountered that with a senator at a town hall. We had to submit meetings in the hallway or questions in the hallway.
And that, and of course, when called to account on things like this, the justifications, we weren't trying to cut off their speech or trying to cut off what they say. We just have time constraints. We have whatever. I mean, there's always the different excuses. Now, I'm always skeptical of those, but again, you know my bias and my prejudice that I come through with this. So, yeah. Yep, go ahead.
Are there any rules, laws about a school board denying the public's parents' continual request to record an open meeting?
So that's a great question. There's so many things I could talk about the Open Meetings Act, but so there is actually statutorily a right to record audio or visual meetings of a public body. As an Open Meetings Act lawyer, I love it when you have an audio or video recordings, particularly a video recording of a meeting. Because what happens is the memories of the way government officials think that the dispute went down is often different than the person who is the receiving end of that action. The government has to give you the right to record. Now, where there can be some rub, and this is a court case I dealt with over in the Port Huron area, is what happens when the government says you have to be all the way in the back. And you can't bring any equipment in other than you have to hold your cell phone physically during the entire meeting, right? Is that a reasonable rule? I mean, kind of sounds, the justification was, well, you're blocking the view of other people. Well, really, though, I think a lot of times who wants to hold their arm up to record for 2 hours of a public meeting? It's to prevent the recording from occurring. But again, my bias, my prejudice. So there is a right, but there is a lot of times those rights tend to be, especially with folks who are on boards who think they shouldn't have to be recorded because they don't want what happens at that meeting to be rebroadcast. Now, in today's world, that's become less of a problem because more people are being used to being recorded than ever before. But because of Zoom and because of a lot of times our response to the pandemic, that we're now using more online meetings in that respect. But there's still a good faction of people that think that the only people that have the right to talk about or to see what's going on in the meeting is those who actually physically came to the meeting itself.
That's the concern, I guess. So that's the personal part. What if the parents are requesting, the taxpayers are requesting that the school provide access to that? Like,
there's no requirement under the Open Meetings Act to do that, but there is the right for a member of the public to be there and to record those meetings that way. So come see me after. I'll talk. Everyone, I'll stay as long as I'm allowed to not get kicked out of the building. So, and I'll talk to everyone about any of these laws. So I thank you for your time today. And if you run any other problems with that, call my office. Thank you.
Robin wanted to clarify something real quick.
I wanted just to follow up on a point that Phil was talking about with this. So just like FOIA and OMA overlap for you to get information up front, there's another way that they overlap that you should think about. So if a decision, there's been a change, and you didn't see any deliberation in open session, and you didn't see a vote, ask for documents, ask for emails during that period of time, because what happens is, if there's a quorum of a public body that's making a decision over email, that's an OMA violation, and you use FOIA to find out what those communications were. So that's just another crossover point that you should be aware of.
And a fun lawsuit for us is when they then deny the FOIA request, so you sue under FOIA and you sue under the Open Meetings Act. So anyway, thank you guys. I appreciate the time today.
So are you still having some difficulty with hearing the questions? Because
Just the audience. So if you could repeat the question or pass the microphone. Senator.
if they're close enough, I'm going to come to you. If you're not, say your question, I'll repeat it into the microphone. I want to mention a couple things that legislatively with these issues. Since I was elected in the House all the way through the Senate, bills that came up that I co-sponsored that would require the legislature and the governor to be subject to FOIA, which they're not, and open meetings. That unfortunately has not got through. There's a bill that Phil and I worked on that these technical violations, such as you post the wrong day, the person shows up and the meeting's already occurred because they posted the wrong day, or they say it's over at the township hall and it's at the library, and you go home and then you've been wronged. That's a technical violation, and we tried to get a bill through that said if that occurs, you have the right immediately to petition the local municipality. They have to reconvene and have that hearing again in front of you. Can't get that thing through. So we're just going to keep plugging away and trying at some of these. Another bill I have is in Oakland County, you cannot get copies of the court record. So if you're in court, they videotape it, but then you get a transcript. You know how that goes. The transcript could be so misleading. It could actually miss stuff. So can't get that one through. Hopefully in the next session, we'll get some of this stuff through. So with that, we're going to open up to questions. If you're close enough, I'm going to come around, and if not, then we may have to have you, I'll repeat your question.
Okay, Keith, this is a question for you. So I've looked heavily into the bylaws of our school and I've noted multiple violations, and I've actually spoken similar to the other video that we watched to our board. But my question is, how are you to move forward and do anything with them making these violations and hold accountability? Because it sounds like to me, you can go in and tell them all this, but unless somebody's going to do something about it, you just have to continue on suffering, watching their violations.
So I'm going to actually give that to one of my colleagues over here, they're the attorneys, because, yes, you're right. Sometimes they violate the law anyway. So now what is your remedy?
Well, I guess let me say this. There's a difference between if you're trying to get a policy change versus you're trying to get a legal change. Because a policy change is, school boards are empowered to exercise discretion as to their policies. I can't go in and say you should have pizza on Monday and nachos on Tuesday, right? I don't have, there's no obligation to that under the Open Meetings Act. Of course, my wife would just be mad that I just picked those two food items just now with that. I'm a cheeseburger and my wife's a marathon runner, right? So she'd go in and say, don't listen to Phil, we should have a salad bar, right? We don't get to make those calls as the unelected officials. But what we can do is that they're having a secret meeting about changing these things. You have a right to see those deliberations, see the vote that they make, and then also do the public participation to advocate at that meeting directly, in which there's no way hamstrings you from sending letters or emails and things like this afterwards. So to answer your question is, if you want to get some of these things changed like that, sometimes you got to use some good old-fashioned political pressure, which is what Kurt was talking about, or Keith. I keep saying Kurt.
Yeah.
I'm sorry. These policy changes that way, or bylaw changes that way, these are the things that you can do Whereas sometimes, the only times that lawyers like us can step in is when we have a specific violation of an affirmative duty to do something under these laws.
Phil, a question I had for you was that when you talked about how long public comment period can go on and if there's any requirements. As an example, there were many public comment periods for the Independent Citizens Redistricting Commission.
Yes.
And there was absolutely, well, at the beginning, they started off with a 2-minute time limit.
Correct.
Then 90 seconds, then 60 seconds. But there was absolutely no limit to how long those public comments would go on. They would take the public comments from the people who were in the building and had come in and registered and signed up. And then after that, they'd go to Zoom comments. So perhaps with like a school board meeting, they would have public comment time. And then some school boards are also on Zoom. I don't know if they allow Zoom comment time. I don't know that. But the Citizen Redistricting Commission often went until one time I was on Zoom. I had my comment at midnight. And it could go on for, there were 12, 15-hour meetings a lot of times. Does the school board have any, are they able to limit the time, or, how does that work?
So the short answer is because of a lawsuit that one of the people sitting up here did, you can't cut off people's opportunity to speak. You can limit the span of time a person can, but you can't limit. So if 100 people want to come into a meeting, this was a case out of Grand Traverse County. If you want to limit the amount of public participation time, you can only limit the individual numbers. You can't come in and say, because what they did up there is they said, we're going to let people have 3 minutes of comment and a maximum of 30 minutes of public participation time. And there was about 60 people that wanted to comment, a very controversial debate they were having. And after about 8 or 10 people, they just said, yeah, we're done. We're done. We're not going to listen anymore.
So I saw an interesting thing happen in Lyon Township where they were discussing a zoning issue that was very controversial. And, Zoom has its problems. Well, they had like 100-person limit, and all of a sudden people couldn't get on the Zoom. And this was it was an essential part of the process. And so the township attorney was on there, and they recognized during that meeting that they actually didn't say it publicly, but they recognized at that meeting that it actually didn't count for public purposes because they couldn't have participation from everyone who wanted to actually be on that meeting. So it stalled that from moving forward on that particular night.
It depends on what the action item is, what the public body is. And the Redistricting Commission, they're not subject to the Open Meetings Act. I was involved in that case. They have separate constitutional obligations with respect to their meetings. So you can't use that really as an example.
Do you have to have standing? Do you have to be in the school district or whatever to be able to get up and speak?
Yes. So that was my example. I didn't have standing because I hadn't gone to the public middle school, right? But that is not a requirement. As Phil indicated, part of the problem is they try and, I would say, shame. Some public bodies try and shame outsiders from saying anything and discounting their view because, well, you don't live here, you don't have a kid in the school. But under the Open Meetings Act, they cannot limit you that way. They can't say, only people from my district can speak. They cannot do that.
I'm trying to get to some new people that we haven't heard from.
Hi, my question has to do with bylaws, and it also kind of goes over into the rules, I think you said, and the laws or the policies. It was mentioned on one of the slides that according to the bylaws, the school board can actually vote to give the superintendents of the schools all this authority to do certain things. And I wanted to know if that authority includes stepping outside the bounds of the laws, like with the masking and the social distancing and the testing and the quarantines. Do the superintendents actually have lawful authority? Because I was at a hearing the other day in Livingston County Court, and the judge mentioned that those superintendent and the policies do not have the enforcement of law. So have you run into that, and what could, all of these people here maybe learn from that instance?
Well, so some of the authority and some of the obligations of school boards and superintendents are set statutorily. So for example, by statute, a school board has to evaluate a superintendent yearly, and there are certain requirements. But generally speaking, you think of the superintendent as the CEO, right? They are the executive officer. And the school board, I think, as Phil said, they're the governing body, right? But then the superintendent executes. I don't know what the codes provide for in that. I thought it was school boards rather than superintendents.
Well, I guess the topic here today, and not to tell you, no, we don't know the answer sitting here right now. We can tell you that, because what we're here about is FOIA is about the right to get access to documents, and Open Meetings Act is how to conduct the meeting. Now, what actions the board takes in that meeting to give itself power, to grant the superintendent power, to formulate policy. For example, we're going to have masks, we're not going to have masks, we're going to test. Those fall under whether other laws give the board the authority to act in that respect. What we're here talking about today is about the basic nuts and bolts procedures of making sure that people either get access to the meeting, how those meetings are supposed to be conducted, and not necessarily substantively what they're deciding. Because what they're substantively deciding could in fact violate a separate law. For example, the public health code, for example. There's a real debate right now, and there's different courts have ruled differently about whether school boards have to follow what health departments order regarding masks and testing. Who's got that part? That doesn't fall under the Open Meetings Act or FOIA. That falls under the other substantive law. But if they're going to take votes about that, they better darn well do it consistent with the Open Meetings Act.
Thank you. Just a quick question. Is there any legal support under the OMA that local boards have to follow their own locally adopted bylaws?
Well, so no, technically no. The argument that's been had is that when a board acts inconsistent with its own policies is that they are impliedly overruling their own procedures. But if their locally adopted rule is to further and effectuate an obligation under a state statute like Open Meetings Act or any one of these things, then that would be a violation not of their policy, but actually of the governing law that governs them. So, I think it looks really bad when you don't follow your own rules, when you're the person on a board whose job it is to dictate rules and policies for other people. It looks terrible, and that may be a political point, but it's not a legal point, I guess, is what I would answer that as.
Okay. I have two quick questions. Hopefully I can make them so specific that it's just yes or no. First of all, let's get
We're
this one.
lawyers, not possible.
First of all, let me ask you a question. On a seven-member board, it's illegal to have a quorum outside of the open meetings, to have 4 members making any decisions or discussing anything. But would it be illegal, which I'm just looking to confirm, I'm pretty sure I know the answer. Would it be illegal, for instance, the superintendent to approach each board member separately with the same question to take a decision outside of a open board meeting?
You want to hand this?
So there's 2 answers. So the first is you can take a straw poll this is the example I use. So pretend it's Keith, Phil, and I, and the 3 people here, right? I'm the superintendent, so I say, will you vote to fire the music teacher? He says yes or no. I ask Phil, will you vote? I ask you, yeah. That's a straw poll. That's okay. A round robin is not okay. A round robin is, I say to Keith, will you vote to fire the music teacher? And he says, yeah, but I want my niece to get the job. And then I go to Phil and I say, will you vote to fire the music teacher? Keith says he will, but he wants his niece to get the job. And Phil says, that's okay with me, but I want my nephew to get this position that's open. And then I go to you and I tell you all of that. That is impermissible. A straw vote, just Yes or no? Will you support this? Okay. But if you're trying to build a consensus and exchanging information, in my opinion, not okay.
And then there's a case that's Arnold Lines, that, you can just know the case. You can do, board members can talk to each other one-on-one about how they're voting. But of course, when you start, we don't do that anymore. We do everything by group text or group email. I think once you cross that line, you're now into deliberation territory, and all deliberations of a public body have to be done at an open meeting.
Okay, I have one more question. With a board that has a general rule that you don't address the board members as your public speaker, but in a situation where non-hostile, professional, a member of the public would get up and want to ask the individual board members a question, doing really nothing scary, nothing wrong, but yet the president tells him if he's going to do that, he will be warned 3 times and the uniformed officer will get him out of the meeting. That's not legal, is it?
So call my office. What's that?
Talk about the Isaac case.
Oh, yeah, this will take a long time to tell that one. I guess short version is the reason why I tell people to record meetings is so that those very things, I can study those things and Robin can study those things and say, okay, let's go piece by piece to say, I would say that if a board president, for example, said, don't address those people or don't address an individual and I'm giving you warning and you do it anyways, I think that's a violation of the Open Meetings Act, but it might not necessarily be a violation of the fact that they still complied with you've been given notice of that you're breaching the peace. What I would then sue on is that the rule that you established violated the Open Meetings Act that way. So while there may be consistent with what maybe the way that they went about doing it was all right, but the underlying basis on why they did it could still be a violation of the act.
Yeah, I had a quick question for Robin regarding FOIA and what could be overly redacted results. And I've seen a table at the end of these results. One example is a very redacted email that the reason was attorney-client privilege, but there was not an attorney on the email. As an example, what is your path to challenge over redaction after you've already gotten your results back?
You can appeal to the head of the public body, right? And if that's not satisfactory, then you sue. Those are your only options under Michigan law at present.
Just to add to that, an over-redaction is effectively a denial, is what it is. So because under Michigan, Robin was talking about this earlier, was when you redact, you have a duty the public body has a duty to redact that which is withholdable and leave the balance of the document available. But if they're going too far, they're actually denying you access to those portions of the document. So you call...
They have to tell you why they are redacting. Look, even if you appeal and they say, no dice, that doesn't mean you shouldn't call a lawyer about it, because sometimes, unfortunately, there's been an attitude for far too long that public bikes, they're not going to sue. They're not going to do anything. They're not going to get a lawyer, right? We need to start challenging those. And sometimes merely having a lawyer write a letter to the public body and say, do you really want me to sue over this, can be very effective.
This question is for Keith. Are there standards through the state on what are considered ethics violations by board members? For example, we had a board member last year on his personal Facebook page, but it was open to the public, post F the police. Our board president did nothing about it, and he's still on the board.
So I am not familiar with any standard like that, and of course, I think it's all up to subjective reasoning, but so, no. I'll tell you, in my case, so we were building this $73 million high school, and there was a vacancy on the board. They actually appointed the vice president of the construction company that was doing the work to fill that vacancy. So what I was able to use that politically to just blast the heck out of them, and then I beat them in the next election. So anyway, sometimes those could be quite political in terms of specific laws, probably not to that degree.
So one thing I was curious about, in terms of the oath that these elected officials take, they take an oath to uphold the Constitution, as I come in, and also to do their jobs to the best of their abilities. My question is, if they have bylaws that they're to follow and they're choosing not to follow their bylaws, have they now violated their oath because they are not following their bylaws according to the best of their ability to do their job?
Same answer as Phil gave earlier, that, we don't know. We're FOIA and OMA people, right? So you need someone to opine on that who knows what the legal obligations are with respect to that generally, and whether or not there are any penalties for that and what they might be.
So I can just tell you my research, I've tried in the past to find a way to sue about violating your oath, and there is no mechanism that's available in Michigan, at least, but don't take my word. We're only limited by creativity, right? So different lawyers can come up with different legal arguments about how that might be effective to be able to challenge that. But as of right now, there's no precedent that's out there. And frankly, I can just imagine a judge going, "Oh, Ellison," But that's what lawyers do. We push the boundaries to try to create new law and create new opportunities to effectuate a remedy when a right's been violated.
Phil mentioned in the Opens Meeting Act, is that correct, that when a board goes into, or whatever goes into closed session, that they have to discuss the topic for which they went in? Is that correct? And so does the topic need to be put out there in the open session? How do you know what they're supposed to be discussing? You said, do you have to do a FOIA, or should it be we're going into closed session for this purpose?
So a couple things. Let me take a half step back. When a public body goes into closed session, they still have to maintain meeting minutes of what occurs in that closed session. Okay. The problem is that those closed meeting session minutes can only be revealed if you bring a lawsuit. All right. So one of the things that, for example, and this is one you might have heard of, the Shiawassee County Board of Commissioners voted to use the American Rescue Fund dollars to give themselves $25,000 pay raises. One of the lawyers sitting here brought a lawsuit against them saying you're violating the Open Meetings Act. When you went into closed session to discuss about personnel issues, you shifted it from personnel issues to how to spend this money. And as a result, you're actually doing how you spend money. If there's any immutable North Star rule, if you're spending money, you better be talking about it in public, not in private session or in closed session. So what happens is that I can then get those closed meeting minutes to see in a court case to say, look what you actually did discuss, and can prove that there's a violation of the Open Meetings Act.
My question is, how did you know that the closed session was supposed to be about public spending?
So under Michigan, under the Open Meetings Act, they're supposed to identify the basis by which they're going into closed session. Yes. And one of the ones that is quite often you'll hear is, we're here to discuss it with our attorney, right? Yeah. Under Michigan law, you actually can only go into closed session to discuss things with an attorney if you have specific pending litigation. And there's a court case out that says when you go into have to discuss specific pending litigation, you have to identify the specific case that you're going to discuss in closed session. So then if we find out after the fact they cheated and lied and went and did something else, we would be able to prove that in court when someone brings a legal action to challenge that.
So I'm aware of a case in Lyon Township a couple years ago where they did not identify what purpose they were and did not record in the minutes. So one of the taxpayers sued them and went up to the Court of Appeals. It was an unpublished decision, but they ruled in favor of the taxpayer, and he won like $70,000 in attorney fees to cover the attorney said, I'll do it. If we win, then I'll get my cut. And so they were able to win because the Lyon Township Board wasn't fulfilling their obligations.
They have to identify the exemption that they're going into closed session for, and when they come out, right, they have to take the vote if they're going to act on it, and the minutes have to reflect that. So they can't say, oh, well, it's what I make a motion to do what we discussed in the closed session, and everyone says aye. They cannot do that. So you are supposed to get enough information to know why they went into closed session and any decisions that result from it.
In our case, I think it tags along with this. In our case, all committees are considered closed, and they bring them to be rubber stamped to the meeting. Part of my question has to do also that any public that are allowed in for, it to be appearance of not evil, is they handpick those people to attend. I don't have any other idea how they get a curriculum committee. Okay, you picked your people to be on your curriculum committee, and no one's allowed to know what's they discussed or nothing.
So this is a topic that's you just triggered on all sorts of things on my back of the hairs of my neck stood up. So because one of the big things that I think our courts have done to our great detriment is try to create a distinction between committees that effectuate policy versus committees that do recommendations. And when committees are done for recommendations, the courts have held that they're not actually a public body subject to the Open Meetings Act. I think that is, and I'm going to say it, that's horse shit, okay? And I'll say it in the worst, crudest way, right? Because every deliberations that are being done in these committees formulate the policies by which public bodies then ultimately act, right? And it might just be simply enough that, if a full board says, well, these 3 board members of our 7-member board thinks it's a good idea, I don't need to hear anymore, I'm just going to go along with it. Well, then the decisions and the debates and the pros and the cons are not being done by the board that's subject to the Open Meetings Act. It's being done by the committee that's not. And that's an area of law that I'm actually litigating a case right now in Mecosta County involving a little village that what they did, and I don't want to go into the whole war story on everything, but essentially this village gave a committee the authority to enter into a contract to rent one of their government-owned buildings to a marijuana dispensary. Hand to God, hand to God. And they debated about the provisions that would be in that contract or not be in that contract, and then said, well, okay, guys, what do we want in here? What do we want to change? And then they got all done and had a contract. They went back to the village council. The village council said, looks great, stamp, and that was done. And the judge ruled in my favor thus far that subcommittee, because they had the power to effectuate policy, is actually subject to the Open Meetings Act. And so my guy was denied the opportunity to speak, his rights were violated. But there's other court cases that have held, for example, there's a Detroit Financial, there's a court case, it's called Davis.
Financial review.
Financial review. And what they said was, well, that was merely a recommendation committee to the oversight board on this, which was, I think it was just the treasurer of Michigan is what it ended up being, a one-man board. And they said that's not a committee that would be subject to the open meeting. I think those decisions are wrong, but we have to lawyers like us have to bring more cases to try to get higher courts to either overturn those, or we prod enough legislators together to change and rewrite the Open Meetings Act.
And what you should be doing in the meantime is, if you don't see due diligence, right, at the public meetings, one of 2 things is happening. Either there isn't any due diligence, or the due diligence is going on behind closed doors, right? So you use the Open Meetings Act and the meeting minutes, and you use FOIA to try and discover whether or not there's due diligence. And if you're unsatisfied, then you say at a public meeting, where's the due diligence, right? Are you just rubber stamping? what's going on. But as Phil says, you've got to litigate those sort of case by case, and oftentimes it's difficult to get the material you need to demonstrate that, in fact, these decisions are being made.
Okay, we're going to have to go real short questions, real short answers, because we have a hard stop, and I know there's a lot of people still want to ask questions. Over here.
Good morning. My first question is, if a board member is appointed rather than elected, are they considered a voting member of the board?
Yes. I mean,
Okay.
I agree.
So then my second question is, if you do bring suit against the board, who is the defendant per se? Is it the district? Is it the board? Is it an individual person?
So the Open Meetings Act provides us to sue both. You can sue a board with
A public body.
Public body, and usually the public body is controlled by a board. And then you can sue the individual board members. And one of the things that's missed by most board members is a violation of the Open Meetings Act is actually a crime in the state of Michigan. It is an arrestable, chargeable misdemeanor to violate the Open Meetings Act. Now, I can tell you, I've been an Open Meetings Act lawyer for 12 years now. You know how many charges have been brought in the entire time? One. And that was back in, 95, 90?
Yeah, Whitney.
Whitney, yeah.
Whitney has new life now, so.
That was a court case that was from the 90s. Prosecutors don't bring these. So we can sue both, but there's a bunch of different, and without really putting my legal nerd hat on here right now, there's a bunch of different legal things we have to maneuver through to say what way we can hold the board versus individual board members responsible or liable under the Open Meetings Act.
Okay, we're getting another question.
I don't know if this is a short answer. We've come a long way from 3 TV networks, 2 newspapers, and a bulletin board in the town square. What constitutes public notice and sufficient public notice? Can somebody complain that they don't have email, they're not on Facebook, and yet all the notice went out there? So that, can they complain that they did not get notice?
Well, this is America. You can complain about anything, which makes it even better, right? But the short answer is that they have to, at least for the regular meetings, it has to be done at the organizational decision of where the regular meetings are established. Special meetings have to be posted in a public place, wherever that means. And if you have a website, it has to be put on the website in addition to the public posting. There's no requirement to email, there's no requirement, but that's where you can tie in what Robin was talking about is, I want a subscription for the next 6 months. At any time you issue one of these notices, I want a copy of it emailed or mailed to me. And that way you can actually kind of make your own notice process to make sure, and if they don't do that, you call your lawyers and we sue on Open Meetings Act and FOIA violations.
Okay, got another?
That's perfect segue, because I was going to ask, is there a time limit on that? Because if you do have to ask for that subscription, but then they email you the copy after the meeting, I mean, it's...
Yeah.
That is a problem, right? Sending you. So one of the problems that you have is, like, if you want the agenda and they say, the meeting's Monday. Well, we don't give the board the packet until Friday, and then we didn't have a chance to mail it out to you till Monday. That is a problem. As the senator said, that's one of the things that we've been looking at in terms of legislatively. But I would complain about it. The other thing to keep in mind is, depending on the violations, both for Open Meetings Act and the Freedom of Information Act, you only have so long to bring claims, right? So if there's a really concerning issue, make sure you talk to someone quickly about it, because, for example, on fees, it's 45 days under FOIA. On some of the Open Meetings Act stuff, there's really no set time limit. On some, there is. So, you want to keep your eyes peeled on that.
Clarkston Community Schools Board of Education, this is an ethics question. There is a longstanding member of the board, 20 years or so, who also is very involved with the Michigan Association of School Boards, who had contracts to provide IT services to Clarkston Community Schools before being elected. And as he's been on the board for 20 years, has continued to have IT service contracts for his company. And when we questioned that, we were told that it wasn't a conflict of interest because the board amended the bylaws and approved that this particular contract wasn't a conflict of interest. That sounded very fishy to us.
So you just asked an ethics question to a politician and 2 lawyers sitting in front of you, right? No problem, right? Again, I think we've just for purposes of time right now would say our case, that's a substantive issue about whether that violates some other law. So long as they voted on it in open session and they've given you the documents under FOIA, there's no Open Meetings Act or FOIA violation, but it might violate some sort of other substantive law that is out there.
Hi, just for clarity, when the board is having their session, they need to open to the public and allow the public to speak, because we were challenged last time with our president of the board saying, hey, we're giving you the opportunity to speak, as if they had owned that. Can you clarify that for me, please?
They have to give you, there has to be a public comment section in every single meeting. Now, one of the tricks that will use is they'll say, okay, well, we're going to have the public comment section at the end of the meeting after we've already voted on the thing you're there to talk about. And it's very frustrating. Actually, there's a case right now I'm dealing with in Roscommon County where they did that very thing where, I mean, the whole point of it, but does it on its real basic face, the language, all the Open Meetings Act says you got to have a public comment. So the answer is yes, you need it, but they sometimes play the games of when they actually will open the floor up for that opportunity.
Okay, I just wanted to confirm something. When they have a special meeting and they announce that they're having a special meeting, do they have to tell you what it's about publicly when they post it?
You go ahead and take this one. I'm taking the floor.
No.
No.
They don't. They don't have to tell you what they're going to talk about any meeting.
By the way,
under the Open Meetings Act, they don't have to give you an agenda. They don't have to give you a board packet. All they have to do is say, we're meeting here at this time, and this is the, that's it.
We're going to do one final, I want to get somebody, if there's anyone who has not asked a question that wanted to.
Yeah, just real quick, the December meeting that you, precursor to this meeting, what was it, is that on YouTube? Is there?
No, it is not.
As a school, if somebody was as a school board member, can you actually discuss beforehand if stuff that to be determined at the meeting and then just present that information at your school board meeting? Say like, hey, this is the substantive issues we've discussed via email, or does it all need to actually transpire during the board meeting?
I'm of the opinion that you can have discussions with members of the public, other board members individually. But if you're doing this mass email, group email, says, hey guys, what do you think we should vote on at this upcoming meeting? That's got to be done because the Open Meetings Act protects not just the decision, but the deliberations leading up to that decision in that respect. Now, where is that line between, I'm speaking to, I had a case like this, I actually had a case like this a couple years ago where the board members were emailing them back and forth, and 2 board members were arguing with each other about what they should do at the upcoming meeting, and all the other board members were just sitting there silently watching, this Jerry Springer event fall in place via email. I argued and was successful in arguing that that was an Open Meetings Act violation because it was deliberations, even though they try to say, well, this is just one-on-one conversation. Well, once you added everybody else to that email, and I'll say the Open Meetings Act was enacted in 1976. There was no email. So the law's not really, it's not really geared towards that, right? The reason the traditional meeting is that the deliberations, individual members, leaders of the community were supposed to get together at a place and discuss the topics at hand and then ultimately vote on them. Well, emails kind of provided a way to get around that. And the law probably needs to be updated to reflect the new technological realities in which we live in.
I don't even think there
All right,
was
we're going to have one final question here, and then we do have surveys that we try to improve everything we do. So any feedback, good, the bad, the ugly, anything at all, please let us know and get those to us before you leave, if you would.
Just a quick question for Robin. You mentioned during your thing about FOIA that incarcerated people are not allowed to put in FOIA requests. How and why did that come about?
Look, it was because some public bodies were getting lots of requests from prisoners for materials.
Who had a lot of time on their
Who had a lot of time, and they don't have, family visiting, so they're following up on stuff. And it just, my understanding is it was becoming really burdensome.
Don't they have to pay for it just like anybody else though?
Yeah, but no, it wasn't.
They can't even make the request for it.
Yeah.
No, that's what I'm saying.
Yeah.
The committee or whoever they're sending to would, if they were allowed to, would bill them so it would cover the cost and the time and everything.
Yeah.
Okay, we're going to have to wrap up. A couple of things. We do have some Constitution, Michigan Constitution, some other materials up here. I want to thank all of you for coming, and feel free to network as much as you would like. And I really want to thank our panel. They've come from a long way. So thank you, and have a great rest of your weekend.